Hi, so today we're looking at the second part of corporate restructuring, and the mode of restructuring we'll be discussing today is arrangement on sale. So, an arrangement on sale is basically a situation where you have a company being voluntarily wound up, and then you have the assets of that company now being transferred to another company. Before we go through the procedure, I just want to explain a few terms that are very important whenever you have to discuss the voluntary winding up of a company. So, during a winding up, you have a liquidator, all right, who's appointed to sell the assets of that company and to distribute the proceeds from that sale amongst the members of the company according to their rights in liquidation. And of course, before he does that, he's required to pay whatever debts or liabilities the company has. Now, another important term I want you to be familiar with in respect of the voluntary winding up of a company is this term, statutory declaration of solvency. Now, a statutory declaration of solvency is basically a declaration on oath that is made by the directors of a company before a company is voluntarily wound up, in which they would state that they have looked through the affairs of the company and as a result have formed the opinion that the company would be able to pay all of its debts and liabilities in full within 12 months from when that winding up commences. And this declaration is required to be made within 5 weeks preceding the date when a special resolution is passed for that company to be voluntarily wound up. So you see, basically, this is a declaration on oath by the directors of a company, which would state that, look, the company may have debts, but is able to pay those debts within 12 months. So essentially saying that the company is not broke, that the company can discharge whatever debts and liabilities it has. So that's another important expression to be familiar with when you're talking about the voluntary winding up of a company. Now, going through the procedure for this type of winding up, the board of directors of that company passes a resolution approving the scheme of arrangement. And then, of course, the statutory declaration of solvency would be made by the directors, and then a general meeting of the company is convened. At that meeting, a special resolution is passed approving the winding up of the company and also appointing a liquidator to sell the assets and to invest the proceeds in the other company. And then after that meeting is held, if you have a member who's dissenting, so he's not in agreement with the whole scheme of arrangement, now that member can write to the liquidator within 30 days of that resolution being passed, asking the liquidator to abstain from carrying out that resolution or to purchase his own shares from him. Okay, so essentially what that member is saying is, look, I'm not interested in going through with this arrangement, so buy me out, pay for my shares, and let me not be a part of this arrangement. Now you see that the way the price of the shares to be bought would be determined would be by mutual agreement between the parties. If the company is a private company where there is no foreign participation, which means foreign ownership of shares, but if you have a private company with alien participation, so a private company where foreigners own shares, or a public company, then the price of those shares would be determined by SEC, the Securities and Exchange Commission. Now, after the liquidator is done with the whole scheme of arrangement, after he has sold the assets and has got proceeds from the sales, the liquidator now convenes a final meeting of the company in which the liquidator would present the accounts to the members. And within 1 year of that final meeting, the company would be wound up. Except where you have an action being brought, maybe by an aggrieved member on the grounds of unfairly prejudicial or oppressive conduct, or where the court makes an order for a creditor's winding up. Now, what I would say about a creditor's winding up is that the court would make an order for a creditor's winding up if, after a liquidator is appointed, the liquidator discovers that the company actually doesn't have sufficient assets to pay off its liabilities. then you see that in that case, a creditor's winding up has to be commenced because the creditors have to be paid off first, before the members can, be entitled to take anything from the assets of the company. So that is what a arrangement on sale entails. It's basically like an arrangement to have the company sold to another company because you have the assets being sold and the proceeds being invested in another company. Now, the context in which this comes up sometimes in questioning is where you're given a scenario where, for instance, a company may not be doing so poorly financially, but faces the risk of running into some financial difficulties, maybe as a result of a change in government policy. Let's imagine you have a company that's dealing in the importation of rice to Nigeria and then distributing to let's say wholesalers, all right, people who are buying in bulk quantity. And then the government now passes a new policy that there's a ban on the importation of rice. Now, that company may be still doing well very financially at the moment, but you see that the prospect is that 6 months down the line, that company could run the risk of facing financial difficulties. So that company could now have this sort of scheme of arrangement where they decide to wind up and then take their proceeds and invest maybe in an indigenous rice producing company. All right. So that's the kind of context in which you see this kind of arrangement taking place. So I hope you've learned something again today, and I'll see you some other day. Bye-bye.